Okay, good morning. If we could get started. I have to say, this is an absolutely wonderful group. Strange and wonderful because everyone in here, apparently, from what I can tell, loves the principles. And this makes it a really interesting conference because last night at dinner, the conversation was the principles. And then when I got in here about an hour ago, immediately people started talking about the principles and sort of picking apart pieces of it. And what about this? And what about that? And so this is just a wonderful experience for me because I'm rarely around so many people that have the same love for the principles that I do. And I'm not going to call it the UPICC. I call them the principles. If you don't know what I mean when I say the principles, you're probably in the wrong room. So anyway, we have a wonderful panel here to start the morning. Um, the principles influence on the development of new UNIDROIT instruments. Now that's a little more narrow than what we're actually going to be talking about, but the issues that we have here are we have the principles, gone through several iterations, but how have the principles been used to influence or other more sectorally narrow documents and instruments? Now that the principles would be used as background source of contract law in things that evolve from this institute is sort of self-evident. We're not about to reinvent the wheel in the house here for contract law. And any more specific type of contract principles, for example, reinsurance contracts and anything of that nature. Obviously, there's going to be some background contract law because if you're talking about contract law in a very specific way, you still have to refer to contract law. So it makes a lot of sense that one might use the principles. But the question is, and this is what I think is going to be interesting with this panel because we got highly qualified experts that can address the question. If you're dealing in a specific area of contract law, why use the principles as the background law? What are the advantages of using the principles? And to the extent that it's been done, has it been done successfully? So I think that's an important question, and the question that hopefully we'll get a lot of guidance and from this panel. We're going to start with Helmut Heiss, who's going to talk about the principles as they've been used in reinsurance contracts. Okay, Helmut, please.
Thank you very much, Henry. And thanks to UNIDROIT and its representatives for inviting me once again to talk about the principles of reinsurance contract law, or what we call the PRICL. In 1935-36, an initiative was taken within UNIDROIT to unify reinsurance contract law. There were some insurers that approached UNIDROIT and asked for an action to be taken in this direction. The circumstances of these days did not allow this initiative to be successful. But in 2016, two reinsurance practitioners, having observed our previous work on principles of European insurance contract law, actually, I did prepare some slides. I'm sorry, I thought they were, okay. I'm still with the first slide anyhow. In 2016, two reinsurance practitioners, one from England, one from Switzerland, approached me because they had observed our work on European insurance contract law, which was dealing only with primary insurance and actually explicitly excluded reinsurance from its scope of application. But they said we need something like this on a global level and dealing with reinsurance law. Taking action, we set up a project group. We received funding from the Swiss National Science Fund, from the German Science Association, from the Austrian Science Fund. And we were very happy to share this project with UNIDROIT, which did take it up in its working programs of the following periods. And that meant for us very much because it was clear that this way we were in the waters of the general movement towards an international or a transnational commercial contract law and in line with the UNIDROIT PICC. Now, the political circumstances in 2016 were, of course, much better to take up such a project than in 1936. But what may make you wonder is, why has there been no action after the end of the Second World War? And why did it take, thank you, why did it take 80 years for the reinsurance industry to follow line with the, after all, very old idea of unifying reinsurance law? And this is why I wanted to tell you that there has been a certain shift that took in the reinsurance industry that took place around the year 2000. And I would like to briefly show you the old school mentality before 2000 and the new school mentality after 2000, which is of course all simplified. In both periods, reinsurance contracts by their very nature were international transactions, and I didn't even mention it because it goes without saying, they have always been by nature commercial transactions. They have been international because they provide their services based on freedom of services, and this freedom of services was guaranteed because in many parts of the world there were no or little regulations on reinsurance. The way the reinsurance industry dealt with the business was characterized by two keywords: the gentleman's agreements and the handshake mentality. The gentleman's agreement mentality can be described with the often quoted sentence, "Deal now, details later." Reinsurance companies would renew their contracts basically by word of mouth or on a very short paper that they called slip that documented only the essentials of the transactions. And all the details were documented much later, maybe in April or May of the same year. And remember, the period would end by December. So you wonder, how could grown-ups doing one of the biggest commercial transactions on the globe, how could they possibly be so careless? And the answer is because this has always been a club. There's only a few actors on the reinsurer side, and they are both very much dependent on each other. You cannot run insurance business on a scale that insurers do if you don't have the capacity that reinsurers provide you with to cover risks. On the other hand, reinsurers, of course, depend very much on direct insurers, and so there is a whole lot of trust among them, and there was no need to document the contract at the time when it was formed. On the other hand, when claims came up, they were usually handled in an amicable way, and whenever a disputed claim came up, usually they were also settled over lunch. There are nice descriptions that have been published by leading practitioners that said that they were going to a restaurant and following a couple of drinks, and since in these days this was all a man's club, after some bawdy jokes, they had some agreement. Now these agreements served the economic circumstances of these days, but did not necessarily satisfy lawyers, neither the in-house lawyers that never knew on which principles those deals were based actually, nor the supervisory law, the regulators, nor were they to the regulators' satisfaction. So what we do see since 2000 is a certain juridification of the reinsurance business. It starts with regulation. Directive 2005/68 of EC regulated reinsurance, not as tightly as primary insurance, but it did regulate it. And those rules are now taken up in the Solvency II Directive of 2009. Regulators, especially in the Anglo-American world, moved for contract certainty. They required reinsurers to document their contracts within short time and as complete as possible. The documents need to be drafted carefully and comprehensively. And in the end, you saw after 2000 a couple of arbitrations coming up and more litigation coming up that also was a sign of juridification of the reinsurance relationship. And it's debated to what extent it is true and what were the reasons, but several are mentioned. The September 11 effect may have may be a cause. After September 11, there were debates on whether those two towers of the World Trade Center that came down, whether they formed one event and were insured as one event, or whether they were two insured events and therefore treated as two separate events. That has a whole lot of importance, considering that there are redemptions for each event in the insurance policies, and you had to decide whether those retentions that were left with the primary insurer applied once or twice. That makes a whole lot of difference. And then you have certain limits per event. The reinsurer is only liable up to a certain limit. And if you add certain losses, two towers, you reach the limit earlier than when you have two losses. So depending on the circumstance, it could be to the advantage of either party to make two losses one loss or keep them as two losses. So a lot of debate and arbitrations went on. The increased supervisory requirements brought compliance issues, and reinsurers did not feel safe anymore to just pay out after some bawdy jokes over lunch and some drinks. They needed some justification that for their payments vis-a-vis the regulatory bodies, but also vis-a-vis their shareholders. And you saw that a lot of reinsurance companies, not a lot of, but there were some that went into what we call a runoff. They terminated business. They did not underwrite new risks. And a reinsurer which is in runoff loses its handshake mentality. Why should this reinsurer regulate claims, settle claims very generously when it has nothing to expect anymore coming back? There's no new business underwritten. There's nothing to be brought back from the direct insurer. So runoff insurers are more stingy, and this changes the mentality and leads to arbitrations and litigations. When a legal relationship is juridified, you need law. And when you observe the world, then you see it's divided in an English world and a continental European world. In English, you have statutory law because the general insurance law provisions apply both to direct insurance and reinsurance. And you have a lot of case law, and you also have several challenging case law that were arbitral awards were challenged in court, and therefore the awards became public. So what you see in England is a law in action, a law that developed out of a certain need, a request from the industry to obtain decisions. Whereas in continental European law, insurance contracts acts usually exclude reinsurance from their scope of application. Article 1101, paragraph 2 of the Principles of European Insurance Contract Law being the main or the general example, taking that up on a European level. There's very little case law because those contracts usually contain arbitration clauses. And since arbitral awards in our world are hardly ever challenged, we don't have court cases that deal with arbitral awards in matters relating to reinsurance. What we do have is handbooks and commentaries, and so it is mainly a law in the books and not so much a law in action. In the whole world that follows the continental European approach, you can call reinsurance law an uncharted territory and not ready for this juridification of the reinsurance relationship. Now, you could, of course, take notice of what's happening in England, and these courts do that. The Swiss Federal Supreme Court has referenced English law. But when you then look at what the Swiss Federal Court is actually doing, you see that it is not following English law. In one case, it's even rejecting the outcome of English case law. And always, English cases can only be persuasive authority. They will never be Swiss reinsurance law. So this is where we saw the need for a private codification within the UNIDROIT framework. And this is what came out. We published the first edition of the PRICL in 2019. It contained general provisions. It contained the duties of the parties based on the principle of uberrima fides, that is prevailing in reinsurance law, on remedies, where we took the approach of a proportional remedy, on allocation, which means the attribution of certain losses to certain periods of insurance, the period of 2021 or 22 or 23. That's the allocation of a loss in relating to the time. And aggregation, this is what I mentioned before. The question, in those rules answer the question whether several losses are to be treated as one loss or as separate losses. And remember, the COVID-19 crisis again was followed now by, or is followed now by huge reinsurance arbitrations. The main issue being aggregation. Is COVID-19 one loss? All the losses around the world are to be considered as one loss within the reinsurance contract. Is it several losses depending on the region, Europe, Asia, and so on? Is it even more losses depending on each country? Or is it even more losses because the canton of Zurich had its own rules on closing business, and maybe this is one loss? Or is it just the individual shop that had to close that forms a loss? And you have millions of losses. This is debated in arbitrations. Some say that the minute the virus came from the animal to the human being, that was the event, and anything else is one loss. Everything else is one loss. Others say, no, it's the individual shop that had to close. So we have millions of losses, and it's about billions of dollars, and this is why it's dealt with so intensively. Now, this contains general rules of reinsurance law. It also codifies to a large extent what has been called international trade usage before. Among the duties, for instance, you have a duty to follow the settlements, a duty to follow fortunes. You have a duty to keep a retention on side of the insured, and so on and so on. And all this has been considered to be trade usage before. And in this point, the PRICL differ from the PICC. The PICC want to codify international standards of commercial contract law. And they say that any international trade usage known to the parties and so on will actually have priority, take priority over the PICC. With us, it's different. To a large extent, we codify international trade usage. And if we would go on giving priority to trade usage, the codification would be without purpose, because the trade usages would go on dominating the reinsurance world. So our rule on trade usage is more restrictive than the rule in the PICC. But this, I think, is the only major difference due to circumstances, and all the rest is very much in line with the PICC. The publication of 2019 was not final. We will edit a new edition in the end of 2024, and you see in red what we add. It's just more reinsurance specific rules. Let me just say a word to back-to-back cover. That means the reinsurance contract contains a clause, this is back-to-back cover or as original, and it guarantees that the reinsurance contract will cover exactly the same insured events as the direct insured. There's never a gap. They are matching cover, as they call it. And we will add such principles. We have also discussed prescription. The reinsurance practitioners that are in our group said we need special rules on prescription. We discussed for days and days and days, and ended saying that the PICC are properly regulating this issue, not only for general commercial contract law, but also for reinsurance. Now, the main task in contents was to bridge the English channel, to sort of make it a transnational principles and bridging the differences that you had in the law in the books in continental Europe and in the law in action in England. And I just wanted to highlight 4 aspects. One is contract certainty. The regulators had already asked for contract certainty, but writing down a contract does not necessarily mean the contract is coherent and understandable and transparent. And especially the aggregation in September 11 cases, in many other cases, and now in COVID-19 cases, has shown that those aggregation clauses in the contracts were very unclear, very untransparent, and they caused so many troubles and now arbitrations. So we installed a rule that would increase contract certainty because we defined the event. Several losses are treated as one loss when they are caused by one and the same event. And the big question in this world is, what is an event? What is an event? And we have defined that. And whenever a contract would now choose the PRICL as the governing law and use the term event, there would be a definition. And we hope, of course, that our definition is clear as opposed to the definitions provided in the contracts. The second and major thing is legal certainty. When you enter as a reinsurer with many, many reinsured in contracts, some come from England, others from Switzerland, some from Italy, some from Saudi Arabia, and others from Taiwan, you want legal certainty. But what you usually do is you choose the law of the cedent. That means in some of your cases, Italian law will apply, in others, Taiwanese law will apply, yet in others, English law will apply. And that will give a different meaning to your reinsurance contract terms, even if you use the same terms. Now we have defined remedies and we have defined typical instruments that are regulated in the contract, like follow the settlement, and we give one and the same background law to the reinsurance transactions. Finally, we provide a global reinsurance contract law, which is the same as with the UNIDROIT principles, because you can choose these principles in arbitrations based on the UNCITRAL model law on arbitration. What were the practical results we reached? Well, in all these COVID-19 arbitrations and litigations, you see the PRICL being quoted on equal footing with English case law. You see it also in other litigations, some that I observe now in Switzerland taking place. Some primary insurers have started to incorporate our PRICL into their contracts. They do not accept the whole set of rules, but they choose some rules like the remedies and transport them into their reinsurance contract. What is not yet happening is that the industry would just plainly choose the PRICL as the governing law. In that respect, they still wait because they don't like the devil they don't know. They prefer the devil they don't know, even if the devil is even more evil than the devil they don't know. They want to just wait and see for the time being, but we are in contact with them and we are sort of disseminating the ideas and trying to bring them to choose the PRICL. We will, in the end of May, have a discussion with a global reinsurance broker who may actually take up such clauses. Thank you very much. And if there's any need for further information, I will provide you with those 2 websites and with my address. Thank you very much again.
Thank you for that very informative talk. And I had a bunch of questions I wanted to ask you in advance, and you've already answered them, which is wonderful. Our next speaker is José Moreno, old friend of mine, who is going to be talking about the principles in international investment contracts.
Thank you very much, Professor Gabriel. The president of the Institute of World Business Law, a prestigious think tank of the International Chamber of Commerce, invited me to join its council. When doing so, he mocked, but simultaneously he meant it, that I would join under one condition. I would have to work hard. Like most council members, I expressed my willingness to do so on arbitration. However, the president posed a challenge, stating that this area was already well covered. You are an arbitrator, but also a contracts professor, he pointed out. Suggest something truly impactful on contracts. With enthusiasm, I propose, why not embark on a joint project with UNIDROIT on contracts and investment arbitration? The potential synergy between both organizations is undeniable, and this could be a groundbreaking initiative. As a member of its governing council, I witnessed how UNIDROIT had recently enhanced the contractual principles, particularly considering long-term agreements, as are typically investment contracts. I also had the privilege of chairing a working group that prepared the ALIC Guide on Agricultural Land Investment Contracts, an instrument that beautifully demonstrated the applicability of the UNIDROIT principles in international investment protection setting. Given the circumstances, a collaboration between UNIDROIT and the ICC's think tank seemed feasible and promising. A project from UNIDROIT, a leading global organization in codifying uniform law about international contracts, combined with the ICC's immense influence on the worldwide business community and the prestige of its standard clauses and contracts, could potentially create a significant impact. Further, it was for UNIDROIT a way of acceding to the hidden treasure due to procedural secrecy of the ICC arbitral awards dealing with the UNIDROIT principles. UNIDROIT had been trying to access these awards for many years, and when I conveyed enthusiastically this possibility to Professor Joachim Bonnell, he replied with caution, "We'll see." Of course, he wanted this to happen, and it finally did. He also reminded me that the 2016 enhancement of the principles fell far short of the initial idea of including more issues on long-term contracts and thus further impacting investment contracts. Both organizations decisively moved forward. The ICC Institute formally presented a proposal in 2022, and the Governing Council of UNIDROIT included it in its 2023-2025 work program. This project addresses the UNIDROIT principles in international investment contracts. Its outcome could be a legal guide or a self-standing instrument in a form of principles with commentary, possibly also providing a set of model clauses reflecting the provisions most used in practice. My idea did not come out of the blue as an eureka moment. At the time, I had been working intensely for more than 6 years in my Hague Academy of International Law course and publication on issues related to applicable substantive law in investment arbitration. In my lectures, I addressed the uncertainties in this context and the necessity of creating further awareness of the potential of uniform law, particularly the UNIDROIT principles, which the joint UNIDROIT ICC Institute project now pursues. Much of what I say here abridges my Hague Academy publication, adapting many of the slides prepared for my lectures. I think we are one slide ahead. Foreign investment is one of the oldest fields within public international law. However, it has remained remarkably underdeveloped for most of its history. At its birth, public international law borrowed legal concepts from ancient Roman private law, thanks to the academic work of jurists such as Grotius, Vittoria, Gentili, and Vattel, who in the 17th century devised justifications for protecting Western Europe's interests resulting from investments in its colonies. In doing so, they borrowed heavily from private law. At the time, private Roman law, the jus commune within Western Europe, was universally regarded as the standard against which to measure justice. Minimum standards of protection were eventually consolidated over time thanks to their adoption in numerous treaties of friendship, commerce, and navigation, and the creation of special international tribunals or mixed claim commissions that resolved international investment disputes and gradually created a rudimentary body of case law. However, the treaties and customary international law in general at the time were spared when it came to investment protection. To fill the gap, contemporary public international lawyers and special tribunals frequently resorted again to private law. Several claim commissions judgments such as Croft, Williams, and Fabiani frequently borrowed concepts entrenched in private law, such as good faith and unjust enrichment. The decisions that emerged from there became recognized as established rules within public international law. Even in the 19th century, most European jurists were trained in Roman private law, which they regularly invoked in their cases. For instance, in the famous 1872 Alabama arbitration, the tribunal dealt with the different forms of culpa within Roman law, among other private law matters such as damages and interest. The equally well-known Bering Sea arbitration of 1893 delved into private law issues, including the doctrines of property, possession, damages, and prescription. At the dawn of the 20th century, the international customary law of investment protection was highly unsatisfactory. Its often vague rules frequently led to varying interpretations, which were reflected, for instance, in the compensation calculation. Several efforts have been attempted to develop and codify custom. 6 codification projects failed between the 1920s and the 1990s. Further, from 1952 until the 1970s, the United Nations proposed several resolutions on foreign investment. These resolutions were highly controversial and primarily useless in practice because they did not customary came under pressure to act, which began agreement on. However, 1998, due to a consensus on comprehensive corpus treaties throughout the centuries clauses to protect foreign investment. So true that the entry into bilateral and multilateral after the second half of the formulation of developed by custom. Their application as these and drafted in broad present. As a result, it comes as no surprise have sparked intense debate in both commentary and case law, leaving crucial questions unanswered. Moreover, several international investment claims involve purely contractual matters. These typically relate to choice of law and dispute resolution clauses and to provisions on currency adjustment, force majeure, limitation of liability, penalty, renegotiation, stabilization, economic equilibrium, and termination, among other matters. Public international law lacks an appropriate corpus to govern these and other contractual issues. Therefore, the overemphasis on the public law framework allowed a wide range of contractual problems to continue unaddressed and even contributed to their emergence. Furthermore, the contractual discussions in the investment context may generate multiple private and private international law questions. Only on some occasions are the parties to a contract and a treaty-based dispute identical. Sometimes the claimant concludes agreements with state-related entities that are not formally respondents in the arbitration. At other times, discussions refer to contracts concluded with third parties. Likewise, contracts of parties that do not intervene in an investment dispute may be discussed in the claim. All these agreements frequently raise private and private international law issues. Additionally, typical commercial agreements have been recognized as investment contracts, as was the case, for example, with the hedging agreement discussed in the ICSID decision in Deutsche Bank versus Sri Lanka. Other cases have dealt with discussions related to finance, construction, electricity, farm out, privatization, sales, services, settlement, joint ventures, partnerships, share purchases, trusts, and many other agreements. Standard contract forms, such as those provided by FIDIC for construction agreements, have also been addressed in international investment disputes. And besides, investment claims may raise discussions of agreements that are not investment contracts per se. Now, contemporary changes within private international law are quite significant and have far-reaching impacts, for instance, regarding nuances to the party autonomy principle, developments on the acceptance of non-state law, or the flexible application of the law. In general, uniform law and comparative law have become increasingly important tools in this new era, also thanks to the response of international organizations such as UNIDROIT and UNCITRAL, and private institutions such as the ICC. Modern conflict instruments also reflect the recent evolution of private international law and may even pave the way for uniform law application. Notably, the 1994 Mexico Convention on International Contracts is open to uniform law, accepts the closest connection principle that can lead to the application of non-state law, and contains a flexible application of the law formula in which, again, non-state law may become relevant. This convention served as a source for the 2015 Hague Conference Principles on the Choice of Law of International Contracts. These principles are open to the application of non-state law, particularly the UNIDROIT principles. The Hague principles, in turn, were particularly considered by the Inter-American Juridical Committee of the Organization of American States, the oldest and one of the world's most successful regional international law organs. In drafting its 2019 Guide on International Contracts and its recently approved Guide on the Applicable Law in Investment Arbitration. These guides explain and promote the application of the UNIDROIT principles in international contracts, the latter with a focus on investment arbitration. The investment arbitration community must be aware of these new developments in private international law, particularly the expansion of uniform law techniques. The UNIDROIT principles represent perhaps the most impressive achievement in uniform law. Since they were initially designed as tools for international commercial transactions, it is understandable that they perform a limited role in investment arbitration at their inception. However, their importance in this field has grown and should exponentially increase if their potential in several contexts is understood well. For instance, the UNIDROIT principles, when reflecting principles generally accepted, qualify as general principles of public international law by Article 38 of the International Court of Justice Statute, as recognized by the United Nations Compensation Commission and in ICSID cases. Further, many of the UNIDROIT principles provisions, particularly on contract formation, validity, performance, excuses for non-performance, and damages, are well suited to international investment and investment-related agreements. In addition to being applied as the law governing the contract when selected by the parties or determined by the arbitrators under the absence of choice rules, the UNIDROIT principles may be used to support the reasoning or to interpret or supplement the international conventions, customary law, and national laws that might apply to the investment relationship, as happened in several cases. The UNIDROIT principles can also perform a corrective role of anachronistic or unsophisticated legal systems, as exemplified in an investment case involving a former Soviet republic. The UNIDROIT principles, I'm close to the end already, were also invoked in the party submissions in several ICSID proceedings. Although the tribunals in these cases do not cite the principles in their decisions, determining their specific influence on these awards remains difficult. While the available information suggests that the UNIDROIT principles have been used in a few cases, their overall significance in investment arbitration practice is difficult to ascertain. Although published works usually focus on ICSID arbitrations, many investment cases are heard before other forums, such as the ICC or other arbitral mechanisms, including ad hoc arbitrations. The resulting awards, which the UNIDROIT principles could have potentially influenced, are rarely published. And even when they are, the parties' pleadings are seldom made public. When delivering my Hague Academy lectures in 2021, I was optimistic about a future in which the applicable substantive law in investment arbitration would be more predictable through interdisciplinary dialogue, in which uniform law, particularly the UNIDROIT principles, would have an important say. Nowadays, I am even more optimistic. UNIDROIT and the ICC Institute formally open a space for this dialogue, creating avenues for groundbreaking work with an enormous potential practical impact on improving the legal landscape of international investments. 30 years later, the UNIDROIT principles are more alive than ever. Muchas gracias.
Thank you, Jose, for that excellent presentation. To all the law professors in the room, you just saw 40 slides done in 17 minutes. That's the way to do it.
Hi, Candy.
Oh, again, thank you. Our next speaker is going to be Ekaterina Pannebakker. She's going to be talking about using the principles to draft sustainable development clauses. Ekaterina?
Thank you, Professor Gabriel, and many thanks to the organizers. It's a great privilege to be here and an absolute pleasure to speak to such distinguished public. I've been asked to discuss the use of the UNIDROIT principles to draft sustainable development clauses in international contracts. And I will start with a short, brief example. Then I will zoom in into the varieties of clauses that can be found out there in practice. And then I will conclude with a couple of points that might be worth further reflection. My example is a recent case published, it's too early, just leave it at the beginning. Otherwise, everyone reads and no one listens to the example. It's quite. It's a recent case of the Court of Amsterdam. It has been published in April 2023. And in this case, a Dutch fashion label G-Star has been found liable for damages for its Vietnamese supplier, for damages for not having placing or having stopped to place purchase orders in a framework agreement. And the court was pretty swiftly and pretty clear. This framework agreement contained no obligation to place any orders. So how on earth has the court come to the conclusion that there was an obligation? Well, the court proceeded in two steps, helped by the councils, of course. The court applied a broad duty of reasonableness and fairness under the Dutch law, but the question remained how to define what is reasonable and what is fair in a situation like that. And then the court found a very short provision in the framework agreement which said that the policy on sustainable development, on corporate social responsibility of the supplier was an integral part of the contract, and it was indeed attached as an addendum to the contract. And there, in very, very broad formulations, G-Star stated that it will take care of its suppliers. And then on the facts of this situation, G-Star was the only buyer of this Vietnamese factory. If they would stop purchasing, that would lead to insolvency of this supplier, and taking care of the suppliers would mean not leading them to insolvency. So that's more or less the reasoning of the court. Well, several questions arise, of course. Based on this, we can continue discussion on reasonableness and fairness. We can think how could the court in a common law decide this case. But I use it mainly to make 2 points. First of all, the use of sustainable development commitments is a pretty frequent phenomenon. Thank you. So frequent phenomenon in international contracts. And possibly, that is the second point, there would be, or there is a trend, a new trend in litigation in all kinds of ways to enforce these commitments, including contract law. And to answer in advance the question asked by our distinguished chair, I think that the UNIDROIT principles can there help to conceptualize the drafting and the interpretation of such clauses. So let me now zoom in on how can it be done. I have found a certain number of clauses available in open access, including the submissions to the Securities and Exchange Commission in the United States and the general terms and conditions of the European-based companies. And then I just try to see what is out there. By no means the selection or the degrees of commitment that I have identified are to be are included or are to be included in the contract. My endeavor was only to classify them and to see what can be done. So the example has probably the most primitive way of including sustainable development goals in a contract is to say, well, they form an integral part of this contract. And then in some jurisdictions, they would be this provision would probably be too uncertain to enforce, and some other jurisdictions, as my example illustrates, they would be too uncertain to enforce in a predictable manner. So the Dutch court went through the reasonableness and fairness as a technique to imply the terms. The UNIDROIT principles would probably go through another doctrine, which would be precluding inconsistent behavior. So it is 1.A, which puts it very elegantly that if the supplier says A at a certain point and say, well, I will take care of my suppliers, I'm part of all kinds of networks that fosters sustainable sourcing, it can no longer act in a way that actually contradicts this commitment. But I said this is probably the most frequent, but also the most unpredictable and weak way to include sustainable development in contracts. One could think immediately, well, could they be more specific? And yes, it would be probably possible. And using the lens of the UNIDROIT, we could think of obligations to use best efforts. And then the reference would be probably the company, a comparable company in a comparable industry. And you would look at whether they really did their best, in that case, to prevent the insolvency of the supplier. But they could still have some margin of maneuver. Another way to conceptualize this kind of commitment under the UNIDROIT principles would be probably unilateral declarations and express and implied obligations. And I will come back to the unilateral declarations later on. But of course, this incorporation of principles in a contract can raise new, rather classical, but new questions like the battle of ECG codes, and what do you do if both parties have a pile of documents and both of them want to integrate them in contract. So the specific provision, either on good faith on specific part of sustainable development goals, could solve this uncertainty. And parties can go even further. They can select key performance indicators in the field of sustainable development, as it happens in certain types of contracts already, and fix them tailor-made in the contract, and then agree that they will be part of the performance of the contract. And once the KPIs, the key performance indicators, are well defined, then one can think of a candy or a bonus or a malus for respecting them or not respecting them. The specific clauses, they do thus have an advantage of legal certainty, which sustainable development goals parties choose, and in which KPIs they operationalize them. But it has a downside, because there's several sustainable development goals can only be worded as a general principle. So for the parties, it is probably wise to still combine the general principles with the specific commitments if they want to cover it all. What is also, probably part of a recent trend is the increasing involvement of multinational, or probably attempts to be involved, or probably forced attempts to be involved in their own supply chains, mainly due to the new legislation. And there are two choices: either go to liability or termination of contract, or invent draft clauses that help performance, that help to monitor whether there is performance and whether there is compliance, rather than immediately go to terminating the contract. And the clauses that help to monitor and maintain the performance are actually clauses that provide a two-stages procedure. So if the supply chain leader, as they called, or another company within the supply chain identifies that there is breach, the contract would first require that they come into the place of this breach and try to mitigate the risk and try to establish or draft a recovery plan with the deadlines, and only then they would proceed with termination of an agreement. So termination agreement is actually probably the most further away from the entire spirit of the sustainable development goals, because what they actually want to achieve is compliance, and not that everyone terminates the contracts, because as we saw in the example, terminating the contract may clear the company from a risk within the supply chain, but it may ruin other businesses, and it can also lead to liability of this company. Different examples of clauses can be found, and with the liability, there are basically also two choices. Well, one can just remain silent and hope for the application of the liability regime. To place an emphasis on sustainable development, a party can say, well, the breach of any sustainable development clauses is so important, in different terminologies, so material, a breach of a contract, that we reserve the right to immediately terminate the contract, which can also have its downside and might be difficult to negotiate, but that is another story. These clauses are only, so you can find the examples, but they are not very frequently included in the contract at the moment. I don't have the numbers, of course, but to hear the practice, one can make this conclusion. But the future will probably change, because there are a number actually of the European instruments that require compliance in the supply chains. The latest directive literally requires the company to be compliant with the duty of care in the supply chains. And one reading this directive would think immediately primarily of liability in tort, but what they do, they actually make an appeal on contract law, because almost all the provisions of the directive need to be operationalized by contracts. So this duty of care should be described in the contract. And that leads me to conclude with 3 points for probably further reflection. And that is, how do we contractually deal, or would want to deal with, the plurality of obligors and obligees? If there would be a direct cause of action under the new instruments for anyone affected by non-compliance of multinationals, or now mainly multinationals, a direct cause of action to claim for damage, then there would be new questions arising in this field. And it might be wise probably for the multinationals to organize their supply chains, or to think about the way they contractually organize their supply chains. And if these supply chains are based on a corporate structure, how do they replace or shift or distribute the risks within these supply chains? And the last point, on another note, the new instrument, probably the sustainable development goals as such, require actually quite a level of cooperation between the parties. And the UNIDROIT principles, especially the last edition, have made a lot of progress on that, dealing with long-term contracts and contractual cooperation. But I think there will be new, very legal questions on that in the new litigations to come. And let me conclude by stating that I am confident that UNIDROIT principles as a living instrument will perfectly cope and deal with the new risks and new challenges. Thank you.
Thank you, Ekaterina, for that. All three speakers came in within their time limit, and I apologize, but I told them in advance. A lot of people don't know this, but there's a little button here, and if you press it, you go down into the alligator pit. And I threatened them with that. So anyway, apologize. It seems to me that if I came away with one thing yesterday about the principles, if I could boil down yesterday to one thing, that is, one of the great usefulness, is possibly the greatest use of the principles, is the way that they're drafted so that they don't favor any legal tradition, and they use language that is understandable within any tradition, and therefore for international transnational contracts, they're particularly well suited. And I think what this panel has shown us is that if we take specific types of contracts that have international implications, that the principles work, because that general notion of its applicability across traditions works within reinsurance contracts, international investment contracts. And as Ekaterina pointed out, just look at the interpretation provisions in the principles, and how easily they're applied across various sectors. So I think that this panel has really emphasized the general theme that we've been hearing for the last day or so. Anyway, questions, comments for the panel? Ulrich.
Yes, I have a question to you, Ekaterina, which primarily focuses on the Dutch case that you cited, which indeed is a very interesting case and probably also a rather risky one. When a clause in an attachment to the contract that says that the company will take care of the supplier essentially amounts to a duty to contract with the supplier. And I would be interested to know, what did the court hold? How many contracts do have to be concluded? Under what conditions? How long does it have to go on? How well does the company have to take care? Is that introducing a lot of uncertainty into commercial relationships?
Yes, the risk of providing such an example without the nuance was, of course, getting they're liable and damages. So the court just calculated the damages because they will no longer place these orders. They said they should have placed, but they didn't, and they don't want. But yeah, your question requires a much more nuanced statement of facts, of course. But I agree with you. This is, and this is probably, I wouldn't know whether the Dutch court would be an outlier and or is it a general trend in Europe? This is difficult to estimate, but I do think indeed that the codes of conduct incorporated in contract and written even not by engineers like the FIDIC, but the marketing departments, that they bring a lot of risks when if you look at them as a lawyer and think nuanced and it is a first instance decision, so it might evolve, but well, it's already several months there. It's an old case, yeah.
Yeah, this is Chris Seppala. Just a question for Professor Heiss. You were talking about this new reinsurance law or principles, and you said it defined the event, but you didn't give us the definition of event. I'd just be curious. How is event defined if it's not too complicated?
It is, of course, complicated. First of all, we distinguish between third-party liability insurance and other insurance. And to just give you the general rule of Article 5.2, paragraph 1, it says where the parties agree on an event-based aggregation. This means we are not regulating aggregation. We are not introducing it as a notion that it would be in every reinsurance contract. It depends on the parties having agreed on a aggregation clause, and this aggregation clause would in some way refer to the event as what we call unifying factor for all losses to be aggregated. All losses that occur as a direct consequence of the same materialization of a peril reinsured against shall be considered as arising out of one event. So we look at the peril that is reinsured, and we look at the direct consequence. The direct is a sort of a limiting factor for the chain of causation that we provide. And that at least makes clear what is the unifying factor. When you observe arbitrations in reinsurance matters dealing with aggregation, a whole lot of the debate is discussing what is the event. Can it be a human-made thing? Does it have to be a non-human thing? Or is the definition different, whether it's a human action or non-human action? Lots of debate. Here, it's the peril that materializes. And then the uncertainties are still there, but they are more confined to certain issues like causation and the length of the chain of causation. But the event itself is defined. And the question, of course, is the market can now say, well, we would have been equally as able to define this event your way, but so far we didn't want that because it was not accepted. So the question is really, are we going to convince the reinsurance and insurance industry that this is a good definition? Not only that it's clear, but also that it's operable when calculating premiums and the risk of aggregated losses. There's, I think, the problem then.
Thank you. By the way, I would love to have an answer to the question, how can grown-ups be so careless? That general statement you made, but we'll put that on hold. Yes, ma'am.
Thank you, Chair. I have actually two questions, one for Professor Heiss and the other one for Ekaterina. For Professor Heiss, first of all, congratulations for the reinsurance principles. I think it's an excellent test, and so congratulations to you and UNIDROIT for this. One of the success of international uniform instruments is not only the test, which actually, as I said, is great in the case of the principles, but also the promotion of the test. And therefore, I was wondering whether the UNIDROIT or the group is thinking about having maybe kind of UNILEX database on this area. I know it's difficult to find cases on this area, as you mentioned, because it's mainly international arbitration is confidential, but still I think there are a possibility of collecting cases and spread the use of the principles, which in my opinion are quite much used in international reinsurance arbitration, as you also mentioned. So that's the question for you. And Ekaterina, for you, I was wondering whether you have this sense of sustainability becoming a kind of lex mercatoria, a usage of trade, and whether you find that this is the case or not. Thank you.
Well, thank you very much. First of all, what you're asking for has come a bit short in my lecture because I had been passed a paper with this threat Henry has mentioned just before. That gave me some anxiety to conclude my remarks. But other than that, we are currently, or let me call it this way. About a year ago, we had our final workshop. All the principles and comments and notes and illustrations are decided. They are not yet perfectly drafted. So we are currently within a smaller group of 5 people that form a drafting committee, revising all the texts, and we hope that we will be able to publish them by the end of this year. Parallel to that, we are already planning 2 things. That is, one, the dissemination and the continuation of the work. The dissemination, for that purpose, we are first of all very happy that UNIDROIT is involved. We have platforms like the one today to spread our ideas. Secondly, that from the very beginning on, the reinsurance industry and the insurance industry and the brokers were involved. So they are now helping us to disseminate the ideas. As I said before, one of our practitioners has opened a contact to one of the world leading brokers, and they are placing many reinsurance contracts, and it will be academics and practitioners telling them on how the PRICL and PICC could be used in the reinsurance business. And then we also try to spread the knowledge of PRICL through databases, but in a first step through, let's say, LexisNexis, Westlaw, Swiss Lex, back online in Germany. We try to place them there so that lawyers who deal with reinsurance not knowing anything about PRICL, when they look for certain words, they will get answers referring to PRICL. And then finally, yes, since we want to continue the work, continuing means to update the principles. Continuing also means to show the results coming in, and a database giving examples of case law would of course be very helpful. So far, the industry is shy of this devil again. They like confidentiality. We have debated why the industry is so much using arbitration, and there's apparently two real reasons. One is the enforceability of the awards globally, and the other one is confidentiality. And they are not so ready to give that up, but I do have indications that some of them are considering. And of course, that would be a breakthrough. I fully agree with you. If we could actually upload and publish arbitral awards on reinsurance based on the PRICL, or at least referring to the PRICL as a persuasive authority. Thank you. Sorry.
Yes, I think you raise an excellent point by asking yourself and us whether sustainable development is becoming a part of Lex Mercatoria. I find it difficult to answer. Well, first of all, I think mainly because of the definitional problems, because if one goes not by the marketing definition of sustainable development, then it's pretty difficult to define. And the goals are actually if you look at them really closely, they could contradict each other. So a very wise interpreter should be there to understand what sustainable development is, and there's a lot of literature in it. But if we take purely the clauses, and if we state that lex mercatoria does include contractual clauses, which then would have some authority widely accepted and repeated use, then they could become probably fitting this definition. Only I don't think that they are repeatedly used in the same way. I think it's probably an emerging phenomenon in contract clauses. And frequently, it's of course not the main obligation of the contract. So they might become part of lex mercatoria. But no. Thank you.
Henry, no, Ulrich, you go. I have a question to Professor Moreno, because you are also one of us with a double function, double head, the investment, but also the general UNIDROIT principles head. And my question is on one of the slides of Professor Heiss, where he mentioned 1.1.2 of PRICL, which reads, issues not settled by the PRICL shall be settled in accordance with the UNIDROIT principles of international commercial contracts 2016. PIC, by the way, there we have PIC suddenly enshrined in real letters. And is that clause, I think in itself, from the general discussion of the UNIDROIT principles, deserves more attention and discussion. It's all about external gaps. Goes over to Article 7 CISG. So generally, would that be a model also for your other endeavors like investment, and generally discussion also for to give to parties when they draft under the UNIDROIT principles, that they use that kind of additional clause inspired by that to distinguish between the contract context and the background law. So 1.1.2 PRICL probably is something which has which will have a much larger impact than just the reinsurance. That your comments on that.
Yes, I don't know if it answers the question, but it hasn't been mentioned yet of the importance of all these moots taking place all over the world using the UNIDROIT principles in their cases. And all this new generation of lawyers, certainly all the new generations of corporate lawyers in my country, and I'm sure in Argentina, Chile, Peru, and other countries, all the ones working in the major law firms involved in international transactions and in investment situations, they have already been exposed intensively to the principles. And in my conversations, many times they don't formally raise the issue of invoking the principles or using them as applicable law or whatever, but they use it as a reference, as a kind of guide to what they have to do when they draft a contract or when they have to deal with certain matters in their arbitration cases. They look to the solution of the UNIDROIT principles, and then, not to sound exotic or not to alienate the arbitrators or whatever, they don't cite the principles, but they use it. They use them for the reasoning and for all that is behind. So I think the influence is much more important as many times realized in that sense. I don't know if that answers the question, but maybe it gives you an additional, it's an additional support to your case of why the principles are so important nowadays in everyday practice.
Thank you, Pascal Pichonard. I just wanted to stress one point linked to this case, because it's a fascinating case that resonated with a different case. Contract is about culture at the end. And there was a case decided by the Japanese Supreme Court in a contract concluded between a German and a Japanese enterprise. And it was a 1-year contract that would renew automatically if not terminated by one party. And after 15 years, one party decided, the German one, decided to terminate or to not renew the contract by saying, okay, now we have found different ways. And the Japanese party said, sorry, you cannot do that. We are in relationship. And the German said, yeah, but we have the contract. Look at the wording of the contract. And it went all up to the Japanese Supreme Court, which said, you know, you have some good faith relationship here, and you cannot, without good ground, decide not to renew the contract, even if the contract was for a 1-year term and automatically renewable unless you would not want to renew it. So there was a kind of good faith permeating through the annual automatic renewal in the whole contract. And one could say, oh, that's a Japanese view of what is a contractual relationship. But maybe through this type of case, we see that this particular view on the role of good faith might come back. I don't want to come back to yesterday's discussion, but might come back. And in that sense, the UNIDROIT principles might also be a basis, in fact, to justify this type of decision. I couldn't help recalling this, reminding you about this case. Sorry.
Something more.
Yep.
I remember an ICC case that I intervened. It was between Paraguayan parties, and the other party was represented by a firm based in Paris. And I remember I cited throughout all my presentation the UNIDROIT principles. And the other party, when answering, said, "But what is this guy doing? This is Paraguayan law. The contract is clear." And so what I did again, that was in the initial submission. So what I did again after is cited more than 20 decisions of Paraguayan courts, including 4 of the Supreme Court, invoking the UNIDROIT principles. So the UNIDROIT principles are very much part already of Paraguayan law in a sense. They have been used regularly by courts in many contexts, and that's a way. I don't want to say things that are probably going to be addressed in the panel of Professor Gabriel and other distinguished colleagues today, but in many ways, national law is heavily influenced by the principles in several countries. Not in all, but in several countries. We were surprised. I remember when we prepared Professor Gabriel the general report for the International Academy of Comparative Law Fukuoka meeting in 2018. I think it was more than 800 cases that we had only from Spain invoking the principles. That was amazing. I think, Pilar, you were the national reporter for that. And so it is happening. The principles are here and to stay.
Thank you. One of the stats that popped up yesterday was the Unilex database with new cases went like this, and then it sort of doubled in a very short period of time, which I think follows your point. Ulrich?
I have a question to Professor Heiss, and in the spirit of the division between law on action and law on the books that you outlined earlier, if you apply your event definition to COVID-19, what is it?
Would obviously depend on the contract, and the peril insured reinsured is defined in the contract, and this is why it's, I say, rather easy to determine. You basically look in the contract and you look at the perils and you say which peril is addressed, and then this peril would be the event. The problem that comes up is if you have a all risk policy, which doesn't specify listed perils, but covers any damage. Then you would have to say, now, what was the peril? It has to be an unnamed peril. And when the contract doesn't name the peril, for instance, COVID-19, what now was the peril? But then you can sort of refer to other contracts or perils usually used in the business, like business closures, and you could say, well, it would be business closures or so, and name the unnamed perils. But there's a definite problem when even with our definition. But other than that, you just look into the contract and say, what are the perils reinsured? And if you have it, then you still need to have what we call a subsumption, right? You have to subsume the what's happening under the text of the contract. So really, you cannot answer it. It's the business closures by country. But in the light of contracts I've seen, I have a certain sympathy for this solution. But again, it really depends. We refer to the peril listed in the contract, and it depends on which peril is listed. But again, for contracts I've seen, I could see that when Germany has business closure orders, that could be considered a peril.
Can I follow up on that? Because it's an interesting question. Presumably there are thousands of cases where this is being litigated. Have the insurance companies gone back and started to rewrite their contracts? Because it seems to me that would be one of the obvious responses, is to clarify this point. Are we seeing in the industry some clarification in case there's another situation such as COVID?
Well, let me say that the uneasiness of the reinsurance industry about the event definition is not new. It has gone beyond any dimension with COVID-19, but it has been the same issue with the World Trade Center and other cases that were decided, especially by English courts. And it was sort of many lawyers have said event. I don't want to hear about this term anymore. And the question is really, you have to sit down and define it. And there have been industry efforts. Swiss Re, for instance, offered a clause, and this clause has been used, and it's now arbitrated in several places because it's not clear. Because very often they circumscribe what could be an event, but they do not name the unifying factor. And in this point, we are different. We really name the unifying factor. We say it's the materialization of the risk reinsured, the peril reinsured, and usually those perils are listed. And we admit that our definition still leaves certain uncertainty when it comes to unnamed perils that are being reinsured. And I think the fact that two representatives of the reinsurance industry came up to me and say, couldn't we have what you have done on the European level with another group on a global level on reinsurance, reflects mainly the aggregation issue. Because the first meeting we had was meeting with reinsurance and insurance industry representatives, asking them what is the problem. And aggregation was on the front line long before, but in 2015, 16, before COVID-19 was even known. So aggregation has always been this problem, and this is an effort of the industry to make it more clear. Aggregation clauses have been drafted and redrafted again and again. Very often they're being introduced to the contracts by brokers, and there is an attitude of the reinsurance industry to copy paste. They have the Swiss Re model, which didn't turn out to be entirely clear, but they copy and paste it, and they copy and paste it from other contracts. And this means it's like a wheel, a spinning wheel that again and again reproduces the same texts. And we try to have a breakthrough here. But it's not only that if you would all agree with me now that our definition was 100% clear, which I didn't say, I didn't say it's 100%, it's just much clearer than what is usually used. Even if you agree with me, it doesn't necessarily mean that it fits the market. You know, it still needs to be accepted by the market because you calculate the premium for the aggregated losses. And the reinsurers will have to sit down and say, can we calculate that properly? Is this a business model at the same time? And so since this is an optional instrument, it depends on the choice of the parties. We have to convince markets. And this is what we are trying to do as of autumn 24.
Alejandro.
My congratulations to the panelists for the seeing again another potential use of the principles in such different areas of the law. I have one question for Professor Heiss and another one for Professor Moreno. And they're both, probably you took very seriously the threat of the chairman about the alligators, send you to the alligators pit. But you didn't have time, Professor Heiss, to talk a little bit about something very interesting. I understood you mentioning about international trade usages in the UNIDROIT principles, which are very hospitable, of course. And you said that that wanted to be contained in your PRICL project, in that PRICL project. If you could elaborate on that point, that would be wonderful. And to Professor Moreno, when you spoke about the international investment contracts, again, well, one question would be whether you have already arrived at a definition of what is an international investment contract. And I guess like in the question of the event in the PRICL is not an easy matter. But if you have a view on that, that would be interesting. And the other fact, when you made a very interesting and useful summary of the international investment law history, but you didn't mention the International Law Commission's draft on state responsibility for wrongful acts. And I guess the soft law that probably may be influential and important. So I think if you can comment on the influence of that draft soft law on what on your project, and whether or not in the working on this use of the UNIDROIT principles, I think it will face the problem of North and South that have not been faced by the UNIDROIT principles in international commercial contracts. Investment law, capital exporting nations and capital importing nations, and you're part of Latin America, have had different views on this issue. Do you expect that differences of view to be important for the working group and for the end result of the investment principles that you are developing? Those are my questions.
Yeah, thank you very much. And let me first of all say, I should have mentioned to you that there is a note being published by UNIDROIT and the PRICL drafting group on the PRICL and COVID-19 health crisis. And some issues of aggregation are addressed there as well. I forgot to mention that before. You can find it on the websites of UNIDROIT and our website. Now with trade usages, all I wanted to say is when you read a court case from the Swiss Federal Supreme Court coming in a jurisdiction like Switzerland, which is the third largest reinsurance market in the world, and at the same time has no reinsurance contract law. That's uncharted territory. So the court says, well, the reinsurance contract law is basically governed by the reinsurance contracts. You look into the explicit wording of the contracts, but those contracts don't have a frame of reference. Usually, you know, you interpret a clause as, let's say, a deviation from general principles of law, and this has an impact on whether you interpret it more restrictively or more extensively. And you don't have this background. So they say, the court goes on to say, well, international trade usage is what influences. And English courts would have a high impact on those international trade usages. Now, if you start codifying those trade usages like we did in the PRICL to a large extent, it's not only trade usage, it's also legal principles, but to a large extent, it's international trade usage, like the duty of a reinsurer to follow the settlements of the reinsured, the duty of the reinsurer to follow the fortunes of the reinsured, the duty of the reinsurer to keep a retention, to have his interest aligned with the interest of the reinsurer, and so on. This gives a different relationship of your principles to trade usage as compared to the relationship of the PICC to trade usage. PICC is strictly unifying legal principles, leaving international trade usage untouched. And this is why trade usage established would actually take priority over PICC. That's my understanding. Whereas when we codify trade usage, we cannot assign priority to trade usage. Otherwise, even in cases where the parties have chosen the PRICL, otherwise the PRICL will not have a scope of application. But turning it around, we are not reinventing reinsurance law. We try to establish what one could call a transnational trade usage, a lex mercatoria. And to the extent we are succeeding in writing down the lex mercatoria, we are not really in conflict with this international trade usage. But we must exclude the possibility of a lawyer going to court saying, yes, the parties have chosen the PRICL and the PICC, but according to PICC, trade usage takes priority, and so we forget about PRICL, we forget about PICC, we only look at the trade usage as it has been done in the old world. This is of course not what we want to go on with. Thank you.
Well, I was afraid of the alligator effect. It was in my initial presentation, the reference to the UN draft instrument. The thing there is that that document does not deal with the so-called primary obligations, but only with the consequences of violation. So again, you don't have there were more than, I don't know, 50 years of negotiations, and finally there was a Roberto Ago in I think in 1970, the contractual matters of the document were expunged in 1970 from the document. So it ended not addressing the relevant issues. That is why I did not mention that document, but yes, all the resolutions that try to deal with substantive law issues of customary international law, not reflecting, as understood by commentary and by, in general, not reflecting what's happening in practice, and that was the reason of the failure. And I don't know that north-south divide. I think there have been happening many things in. Let me talk about my region, Latin America. Since the 1990s, all the countries have modernized their arbitration law, open to non-state law. That brings new awareness of lots of things, among them non-state law. Then you have the also massive ratification of the Vienna Sales Convention. Many countries in Latin America have done so. So the divide there is broken also. Then you have many countries. Let me talk about Paraguay. The curricula in the law schools of the main universities, they already deal with the UNIDROIT principles in the contract law subject. So you have there, you have books, textbooks in Paraguay explaining contracts from a UNIDROIT principles perspective also. You have, I introduced to the judiciary school a topic is something like a transnationalized interpretation of civil law. So I have judges and other members of the judiciary exposed to interpretation of Paraguayan law using the uniform law, using UNIDROIT principles and other techniques. So I think nowadays the situation is different than perhaps the 90s, where there was so much resistance initially, not only on the regarding the UNIDROIT principles, but also even the Mexico Convention. When the Mexico Convention was approved in 1994, it was rejected strongly, but a mainstream doctrine in the region, the scholars in the region showed a strong resistance to the Mexico Convention. But then many things happened after that. The arbitration laws, the Hague principles that again were approved by many countries of the region forming part of the Hague Conference. And then the modernization of several laws. You have, it was mentioned yesterday, the Paraguay, you have Uruguay, then you have Venezuela and Mexico, because both ratified the Mexico Convention. That's already 4. Then you have Panama. Panamanian law is also open to to non-state law. You have 5 countries. Then you have a bill in Brazil. Out of time. Have to shut up. I'm afraid of the alligator.
I'd like to thank the panel. This has been an excellent, excellent set of presentations and discussion, and thank all of you as well for your participation. And with that, we close the panel and go to the coffee break. Thanks.